appeal in the matter of Marlborough DP Limited and HMRC.
Yes, Mr. Finch.
I'm very grateful. My lords, my lady, good morning. Please may the court take up the authorities, Part 7A. That's Volume 1. And please may I start at page 9. It's section 554A.
554A.
Yes, my lady.
Got it. It's been there before, and I'm not surprised we're coming back to it now.
So, what I was saying yesterday was that Part 7A is in the family of tax charging provisions, self-standing tax charging provisions using this in connection formulation. It's not in the family of general earnings using a causal from test or its close cousin by reason of employment test. They're different. Please now I take the court through 554A to make good what I say, that on the facts that we have got and this court has got, it applies all right. So, looking at one, we have an employee, tick, we've got that. That's Dr. Thomas, because employee who's director. And we've got an employer, tick. Is there an arrangement? Yes. Now, it's convenient, please, if I may tell the court, that I say the component parts of the arrangement are 1, the resolution that makes the trust, 2, the trust deed, and the ancillary documentation where the trustees delegated functions to UP Holdings, and UP Holdings entered into this fiduciary arrangement with MTL. For my purposes, that's detail. 3, the resolution that makes the contribution at a time when Dr. Thomas knew he'd be asking for this loan, and he was going to get it. And also part of this arrangement, as it evolved, further component part, that the contributions went direct to Dr. Thomas's management company, MTL. Those are the component parts, I say, of the arrangement. An arrangement's very wide. It's a very typical formulation what an arrangement is, and I'll show the court that. We've got a relevant step, and you saw this yesterday. I'll show you again very briefly today. There are several candidate relevant steps. There's earmarking, 554B, where there's an allocation of money. And on any view, we've got a relevant step, 554C, which is making a loan. That's paying a sum of money, and that includes making a loan. That's express specific. By a relevant third person, that means somebody, that's little 7 little c, who's not the employer and not the employee. So the focus in this case...
Sorry, who's the relevant third person in our case?
It will be one or more of either the trustees BTIL or UP Holdings, because it delegated its functions to UP Holdings, or MTL, that's Dr. Thomas's service company, personal management company. So the question that we're focusing on is, do we have in this arrangement a means of providing or an arrangement otherwise concerned with the provision of loans in connection with Dr. Thomas's directorship? And I said to you yesterday, well, of course we do, because that resolution puts money into the trust, and that Dr. Thomas did that as a director of MDPL, the only director of MDPL, knowing he was going to ask for a loan, and he had chosen that loan was going to be made to him. Now, I hope I'm not going to have to keep saying this because it will get boring, but it's what this case is about, so I'm going to have to bring it up every so often. But that is the connection right there. That the Dr. Thomas used his office of directorship, which is an employment for other purposes, to make a loan to him. And if you turn the page at little 12, you'll see, because we know it has to be the essence.
Forgive me for taking you back to what we were just looking at, in the middle of page 9. I noticed that after the words "in connection with A's employment," there are also these words, "or former or prospective employment." Does that help us at all in understanding what this is all about? Because it could be that somebody's no longer even an employee. Does that matter?
It might matter if you have, take an extreme example, a day 1, day 2 scheme. You're going to be a director tomorrow. Let's do the scheme today before you're actually appointed as a director. So that's a prospective directorship. Or you're a director today, let's wait till you retire today. But it's all, this loan is still in connection with, to do with, I'll take you to, of course, to the cases, but to do with that directorship you've got today. Let's do the scheme tomorrow once you've retired.
Yeah, I may be barking up the wrong tree here, so help me. If you had a former employee, which seems to be within the terms of this provision, if the purpose is to avoid income tax on earnings received for employment, how would that work in the context of a former employee?
Well, it would be a world in which the employee, he or she had done their work, as I say, on day 1, and one way or another, there was going to be a payment which was connected to that work on day 2 as either a reward or a recognition, one of those, or if you're talking about loans, and I'm going to show you more about loans, but if you talk about loans, it's a loan that wouldn't have been made but for the fact they were an employee today. And the question then is the value of that loan caught? So in each case, we're asking whether we're talking about an employment or a directorship which is on foot, or whether it was one that was going to happen, prospective, so that's a question of fact, or whether it was an employment that has happened, but it's terminated, it's finished. It will be a question of fact as to whether the reward or the recognition or the loan is to do with that employment. That is a question of fact. Is there a connection? Is there a relationship between yesterday's employment and today's loan? Sometimes it'll be obvious. If a company says, well, we are going to make you a loan, let's wait till you've retired. That's in connection with the former employment. You are going to be an employee, but not until tomorrow. We'll do it today. It's called by this.
Right.
And it shows the expansive nature of 554A. I'm not sure I can help you much more, my lord, but the ambition of the draftsperson when they've adopted this in connection formulation is to say, I want to catch rewards or recognition or loans which have something to do with either your employment which is on foot, or yesterday's employment, or tomorrow's employment.
Mr. Ghosh, presumably this formulation in connection with is not something that is unique to the employment context. Presumably one sees it elsewhere in the tax code.
In the tax code and elsewhere.
Yeah, well, let's confine ourselves for the moment, at least, to the tax code.
Yeah.
We've seen it in London Luton, for example, in other contexts. But is it an old formula? How far back does it go?
I don't know, my lord, but the cases I want to show you, I will show you. Barclays, that is specifically in connection with. Mather, that's also in connection with. And then Part 7A, there's a case strategic branding, which is literally the same scheme.
Yeah. If the subject were free of authority, and I know it's not, but if it were free of authority, at first blush, it might be thought that these words, or is otherwise, or is connected with, are just ordinary words of the English language. It might be said that they don't need any further elaboration, because there's always a danger of putting a judicial gloss on the words of Parliament. But I would appreciate some help from you, if you don't mind, of how it came to be that actually that's not the approach that's taken in the authorities.
I find myself wondering about that, my lord, because please may I respond and then make my response good when I show you the cases?
Yes, of course.
And this, I think, I hope is going to be helpful. Yesterday, when Marlborough were making their submissions, there was a talk about anchoring. In other words, how do we apply this code in a way that's predictable, consistent, doesn't offend legal certainty? Answer, if you've got an arrangement, as I say, widely defined, but we've got one of those, where somebody who's not the employer takes a relevant step, earmarks money, pays a reward, makes a loan. So you have done something which is outside the norm. That gives you the anchor. Because you say, well, I've got here an arrangement where a non-employer is making this relevant step, earmarking some money, for instance, making an asset available, or in our case, making a loan. And if that's your anchor, that then gives colour and meaning to the words in connection with. And absolutely as ordinary words of the English language. The approach in London Luton, I'll show you this, actually was that. In London Luton, what my Lady Justice Whipple did with Lady Justice Falk was to say, right, we are going to find out what conversion means. That means something physical, huh? That tells us quite a lot about what in connection with means, because those fees that you pay, the developer's fee, the capital amount, the capitalized interest, they don't really have much to do with the physical conversion to bring this building back into reuse. And the identification of conversion as meaning something physical gave this court really quite an intelligible, predictable, consistent, words of that nature, exercise to say, well, all right, I found that out now. If conversion means physical, in connection with bringing a building back into physical use, tells me that I've got to see something which connects the money you're spending with physical conversion that brings this building back into reuse. And that tells me it's got to be direct and close. it's an iterative process, but it's a danger of overthinking this. I'm actually quite content to accept that in connection with this are ordinary words, meaning to do with.
Well, you'll have to show us the authorities, because I'm
I'm
not sure that is how the authorities regard them, although perhaps they do. Maybe it depends on the context. I don't know, but we're certainly going to need your help.
I will, my lord. To trail what I'm going to show you, when I show you Barclays, when I show you London Luton, when I show you Mather, is taking that phrase in connection with, as just meaning what it says, to do with. You locate that phrase in the context of the section it's in. Call it anchoring. What you don't do is to lift it up in isolation and say, let's give this a sensible meaning in isolation. You know the conversation you had with Mr. Firth yesterday about payments to charity. In my respectful response is forget all that. Anchor the scrutiny of what in connection with means, what to do with means, what Parliament meant had to be satisfied to have a relationship between employment on the one hand and the relevant step on the other.
Well, can we just leave those examples to one side and so easily? Suppose, because you rely on Dr. Thomas's resolution, qua director. So suppose he had resolved effectively that the money wouldn't end up back with him, but it would go to a charity. Wouldn't there, if you're right that all that's needed is the fact that he acted as a director, doesn't that mean that that's also in connection with his employment?
My lord, yes, it might be, but it doesn't give rise to a tax charge.
Right.
And that matters, because what the draftsperson is doing here is to say, I'm fixing a tax charge. I'm fixing a tax charge if there's the following component parts. 1, a relevant arrangement. 2, employment. 3, those two things have got a relationship, and the tax charge is on the employee. So a world in which a director resolves to pay money to a charity. Let me just find it. Isn't in this section at all, because the money, that relevant step, has got to be paid to the employee. It's a relevant person. I'm going to show you that. It's 554C, page 12. But if you please bear with me, that's the danger of taking that phrase in connection with and saying, wow, this is really wide, really very, very wide, very, very, very wide. Where are we all going to be? Answer. You don't start there. You start with asking, do you have a relevant arrangement? Do you have an employee? Is there a relevant step where money, in this case, finds its way to the employee, not to a charity? Then you've got a tax charge if there's a connection. So my respectful submission, it's not good enough to attack what I've just said, to say, but that same director could have resolved to pay money to a charity. That is not a relevant step where money is paid to a relevant person, namely the employee.
Right, thank you. Now, I interrupted you. You were going to get to another provision.
Well, let me put my thread back up. I think what I wanted to say was this. Looking at the question for this court, in little 1, little c, you've got my point, which I've made over and over again, but I can't help it. As I say, it's what this case is about. Is the relevant arrangement a means where Dr. Thomas is concerned with, or a means providing Dr. Thomas a loan in connection with his employment? Well, I've said yes several times, because he resolved to tip money into a trust knowing he was going to get that money as a loan to him. He chose himself. How can that be not connected? And I will deal with the points that, well, companies act through the directors. What about payments to charity? I have a little bit already. But as a matter of language of 554A, what I'm giving the court in making these submissions is that free of authority in connection means to do with. Is that loan to Dr. Thomas to do with that resolution he made as director? Of course it is. That's not assertion. Of course it is. It's the very mechanism he used. If you look at little 6, please. You see how expansive the draftsperson wants to be. For the purposes of 1C, so that's the very question that this court's being asked. It doesn't matter if the relevant arrangement doesn't include details of the steps which may be taken, with providing in essence rewards or recognition or loans, so on and so forth. And the reason I showed you 12, and it's picking up a point made by my Lady Justice Whipple yesterday, because of course this section needs to be anchored, but I've given you the anchors: a relevant arrangement, relevant step. Essence means substance, and this is the draftsperson simply saying, look at everything.
Sorry, I missed that.
Little 12, my lady, my submission is simply saying, in asking what the substance of the relevant arrangement is, look at everything.
Mm.
That's it. Now, looking at 554C, because you have to have a relevant step, here it's the loan. That's at page 12, please.
Yes.
You won't, this section only bites if you've got a relevant step. Here we're talking about the loan. By a relevant third person, so that's the trustees, to a relevant person. A relevant person means, if you look at little 2, little a, for our purposes, Dr. Thomas, not the charity.
I'm sorry, can we just take that a bit more slowly? Subsection 2, paragraph A.
Yeah.
Relevant person means A. So here that's Dr. Thomas.
That's Dr.
Right.
Thomas.
Or it can be a person chosen by A, or within a class of person chosen by A.
Yep.
So why could that not include a charity nominated by him?
Can I come back to that?
Of course.
Because
Of course, I suspect that, as is often the case with the tax code, there are going to be interlocking complex provisions, and the whole point is that you can't take one provision out of context, because you have to view it in its entire context. I understand that, if that's going to be the submission. But I was just making the point that it doesn't necessarily, on the face of these words, the payment doesn't have to be directly to A.
there's a kind of punchy technical answer and a woolly, this is how it works answer. The punchy technical answer is that if you look at little 1, the sum of money's got to be to a relevant person.
Yeah.
And that could be A or a person chosen by A.
Yeah.
And that tells you, it's a bit like the point we're going to come on to when we look at the contribution. It makes all the difference in the world if I manage to get myself into a problem where I say pay me and I shall redirect it to the charity. Well, that's a problem. Or just pay the charity. So 1 gives colour to 2, because nobody is saying that a payment to charity is caught.
No, that seems to be common ground.
We are saying a world in which I, because of my directorship, I'm able to, I'm the only director, able to secure a loan made to me, nobody else, That is a connection.
Hmm.
But I'll come back to that.
Yes.
The woolly answer is, well, the nobody's saying this section will be, this code will be applied to a payment to a charity.
And certainly I didn't understand Mr. Firth to make, in fact, I think he disavowed that when I asked him.
No, but I have to meet it, because what's being said is, oh, but it must catch a payment to charity if I'm right. I'm saying, no, it doesn't.
Right.
But can I come back to that?
Yes.
Then you've got the 554F. And do you have, please, there with you, section 176? It was handed up yesterday.
But you wanted to look at F, do you?
Yeah, 554F, page 19. And if you also, as I say, please. So this is the exclusion from this regime. And this is going to come back, as I say, I did promise I'd come back to the point you've just raised, my lord, and I'm going to come back to it now, but once I've showed you 554F. (176), what that says is that a loan in ordinary commercial terms means very broadly a loan made by a person whose business it is to make loans, so like a bank. 554F excludes a loan on ordinary commercial terms, so one of those, so long as, if you look at little b, there's no connection between that, the relevant step, and a tax avoidance arrangement. So that tells you the following. One, the draftsperson thinks absent 554F, that loan would be caught. Two, the sort of loan we're talking about that would be caught without this exclusion, if you please see section 176, is a loan by somebody whose business it is to make loans on, broadly speaking, commercial terms, which they make to everybody. So what this is looking at is absent 554F. The sort of loan that would be caught would be a bank that made a loan to an employee by happenstance. The employee was both a customer and an employee. As long as they weren't involved in a tax avoidance arrangement, all right, that kind of loan's excluded. That's what 554F says. That shows how expansive. Now I'm going to come back to my lord's point with the court's permission. The notion of as to how expansive the scope of 554A when it looks at loans. Now, so the draftsperson thinks without that there's a sufficient connection between a loan made by a bank to somebody who happens to be an employee. As long as that loan's available to everybody on good terms, don't worry, it's excluded if you're not involved in a tax avoidance arrangement. Now, going back to the point about the payment to charity, on that reasonable to suppose test, bearing in mind what I've just said about all loans, the draftsperson thinks that pretty much all loans are caught, even if you're a customer of a bank, if you happen to be an employee. We're asking, well, is the relevant arrangement in essence one, wholly or partly to do with the employment? Where the director is behaving as a mere cipher, it could have been anybody who was a director. Then that connection is either displaced or diluted, words of that nature. It's a PA Holdings type point. The connection with that individual, say it was Dr. Thomas who said, MDPL, we're not going to do this scheme, we're going to make that loan of 100 to a particular charity. Then we're in a place where even though you might have a relevant step, so going back to the point that you made, my lord, it's somebody that Dr. Thomas has chosen. In essence, that arrangement of paying the charity is not to do with loans in connection with his directorship. It's not to do with his directorship. He's behaving as a mere, cipher is the wrong word, but the directorship is a mere mechanic to make for MDPL to make a payment to charity. That's the sort of thinking that my Lord Justice Moses delivered in PA Holdings. He said, look, there was no priority provision there. It wasn't like this case where you've got a priority provision. What he said was, you only got these shares, employees, because they're employees. Yes, these are dividends. But you only got these shares and these dividends because you're employees. So in truth, the dividends are earnings. Here, a world in which Dr. Thomas says, I'm a director, I want the company to pay money to charity, even if the charity counts as a relevant person. The essence of the arrangement is not a loan in connection with his directorship. The essence, the driver, on those facts, is for MDPL to make a payment to the charity. Here, you have got the essence of the resolution to make a loan to me. And just because the same director might make a resolution, one, for the company to pay to charity, and two, a resolution to fund a trust that will in turn make a loan to me, that doesn't undermine my submission. That the second one is in connection with my employment, all right, and the first one isn't. I mean, if you want guidance, construing the facts realistically and applying these ordinary words of the English language, that's another way of looking at this. The charity example, looking at the facts realistically, is that payment to the charity, even if that counts as a relevant step, because it's a person chosen by Dr. Thomas in connection with his directorship, relevantly for the purpose of this section in fixing a tax charge on Dr. Thomas. No. But that same resolution, I can't face saying it again, I think you've got the point.
Yes.
And it doesn't take much grappling with. You have to look at the facts realistically and say, is that relevant, is that payment under this relevant arrangement by a relevant person in connection with a directorship or something else, something other. The charity is something else, it's something other. If there's more that the court needs from me, then of course I'll deliver it. But you look at the facts realistically.
Thank you.
And little one in section 554F does give colour to little 2 because it's all looking at payments directed, sir. It's trying to fix a tax charge on an employee. And then look at 554Z2. It's on page 63. And if you've got that, clip that I handed up yesterday, you'll see the charge to tax under distributions. That section 382 by Toya.
What am I looking for? Did you hand this up yesterday?
Yeah, yes, my lady. I had
Yes, got it, funnily enough. Yeah. 382.
I'm very grateful. Thank you.
I don't have it yet. Yes, this is from Tolly's Yellow Tax Handbook.
That's right, my lady.
Yep, got it.
So 554Z2 tells you, let's say we're in 554A, how do you work out the tax charge? And that says, well, the value of it is in 554Z3. We'll look at that in a moment. But it's little 2 that we looked at yesterday. Do you remember when I trailed my submissions?
Yes.
And little b says, if the relevant step, so here it's the loan, gives rise to any income of Dr. Thomas, which would be dealt with under Chapter 3 of Part 4 of ITOI. So that's the distribution tax charge. That's what you've got. Sub 1 applies instead of that provision of Chapter 3 of Part 4. So this is the priority rule. And again, what this tells us is number 1. If in this case the loan is the distribution, and I've said it more than once, that's the revenue accept a loan could be a distribution, but it's an odd distribution on any view. If the loan is a distribution, there's no double tax because there's priority. And it shows, it's the same old message. The big message is Part 7A can catch all sorts of things, including a world in which a receipt is simultaneously a distribution and within Part 7A. This is relevant if the loan's the distribution. And just to trail what I'm going to show you, I want to trail it now because it's a convenient place to trail it. If the contribution is a distribution, I've got 2 things to say about this. Three things actually. Thing number 1, there was a finding that the contribution was not related to Dr. Thomas's shareholding, but I'll make that good when I show you the FDT decision. Thing number 2. It shows the scope of the in connection with test. It shows it's expansive. 3. Now, this is going, as I say, to this question of whether the contribution is a distribution.
What's the, sorry, I wrote that down and I wondered what that meant. If the contribution is a distribution, do you mean if the loan is a distribution? Or
No,
the other bit.
there are two candidate distributions here, my lady. The first is the loan which was funded by the contribution.
Yeah, so there's, yes, okay.
That's
I sort of call it
one.
step 1 and step 2, but the contribution mean the money leaving
MDPL.
MDPL. Yeah.
That's the other candidate. Just looked at in
Going into the
isolation.
trust?
Exactly right, my lord. Exactly right. That's the other candidate. Now, the Upper Tribunal didn't think that was a distribution. But that's what Mr. Firth majored on yesterday. Because his point was, if that's a distribution taxable in the hands of Dr. Thomas, that's one tax charge, and then the loan is another one.
Yep.
And my response to that is, first, absent the provisions I'm going to show you, 554, Z11B and Z11C, might have been a respectful so what. You've done a scheme trying to get simultaneously a CT deduction and a tax-free loan. What you've actually managed to do is buy yourself a tax charge because it's a distribution, and you're taxed anyway. That is not the revenue's problem. As it happens, that wasn't the revenue's response retrospectively, because what FA 2017 did, I'll take it short now, and I'll, with your permission, was to say in that world in which there was an earlier step that gives rise to an income tax charge, and Part 7A applies. In that world, if you, very broadly, to the extent that tax is due on the earlier step and you've paid it, that is a payment on account of the Part 7A charge, and vice versa. If what you've actually done is pay the tax on Part 7A, that counts as tax paid on account of the earlier step. And that applies to all relevant steps from April 2011. It's retrospective.
So this is legislation which was enacted in 2017,
Yes, my lord.
but had retrospective effect to April 2011,
Exactly.
which is when the legislation with which we're concerned was first brought into force in the Finance Act of that year.
Exactly right.
Do you say that's another means by which Parliament has sought to avoid any problem of double taxation of the same income? Is that right?
It's not the same income. It's of the same arrangement, of the same scheme.
Sorry, of the same arrangement.
Yeah.
Yeah. But insofar, is this your answer to Mr. Firth's submission that if his interpretation is rejected, if the FTT's interpretation of in connection with is rejected, it is going to have the consequence that there will be double taxation? And you say, no, there won't be.
Well, I'm saying no, there won't be, because Dr. Thomas has held out for long enough, because it came in 2017, and he's not, and so these provisions apply retrospectively to his scheme. But I'm also saying, my lord, even if these provisions had not existed, my response would be a respectful so what?
Oh yeah, no, I understand that.
Yeah.
Yeah.
I wrote down respectful, it's tough. Is that right?
Well, along those lines, yes.
You'd say that was that the scheme was implemented as the arrangements put in place as they were put in place, and the tax falls where it falls, so that you wouldn't use the fact of double taxation as an aid to construction in these circumstances.
Exactly right, my lady. And the reason I do that is because it's not double tax of the same income in the same person. It's two distinct steps in a scheme trying to get simultaneously a CT deduction and a tax-free loan.
So it's two steps with the, notionally you could say perhaps it's the same income, but it's been characterised in different ways for each step. been. There's not even a tracing thing. We don't. I mean, it's difficult to say whether it's the same money or not. It's, the purpose of the arrangements was that the money should go round in a circle.
There's no question that's right. Absolutely, but it's a scheme.
Mm.
It might even be the same £100 notes, but frankly, who cares? Nobody asked them to do this scheme. If they've managed to manufacture a tax charge at the stage of the contribution and then another one at the loan, that is not my problem. But as it happens, it's nobody's problem retrospectively. That's all I want to say about that. So what I want to make, please, having shown you these provisions, are the following points. One, the language is expansive on any view. Two, functionally, what I keep calling the anchor, relevant arrangement, relevant state by a relevant third person. So again, going back to your charity example, I can hardly bear to do it, but anyway, going back to your charity example, my lord, that payment to charity, if it was just done by MDPL, wouldn't be by a relevant third person. It would always be normal. You're not on this stuff at all. This really isn't a problem, the charity example. There are many answers to it. The most obvious one is that if MDPL makes the payment to the charity, there's no relevant third person making a relevant payment of a relevant step. Yeah. Thank you. The revenue also confirmed what I told you about the essence of that arrangement to the charity not being to do with benefiting Dr. Thomas. Yes. But this is very important because the revenue can't and shouldn't be able to run away just by saying we're the revenue. Don't worry, the section behaves in a particular way and trust us. I'm not saying that. Your charity example, I'm very sorry, my Lord's charity example doesn't work as any sort of attack on my submissions because it's not in this provision at all. It's not being made by a relevant third person. Yeah. So forget, even if it is, the essence of it isn't to benefit Dr. Thomas. Context. I've shown you the expansive nature that all loans are caught. The type of loan excluded is very, very narrow. That's 554F. Now, the explanatory notes that you looked at yesterday, spotlight, all that. I make the following points. One, the correct and proper approach to construing statutes is that the biggest clue to what Parliament wants, her intention, are the words. Of course, one can look at explanatory notes, and in Cobalt, the Supreme Court, what it looked at in Cobalt, because it was grappling with what the phrase under a contract meant in Section 298 of the Capital Allowances Act. And what the Supreme Court was grappling with was a world in which if I wanted these capital allowances, if I wanted these tax allowances for payments under a contract, the contract had to be in place within 10 years of a particular date. And what had happened was that contract had been varied after that 10-year, that 10-year cutoff. And what the Supreme Court was asking itself for the purposes of Section 298 was, it wasn't until that post-10-year variation, because the changes to the contract were extensive, it wasn't until after that post-10-year variation that the actual obligation to spend the actual money in question arose. Because imagine a contract that says, I will build a small building. It was varied after 10 years to say, well, I didn't mean small building, I mean a big building. And what the Supreme Court said was, we're not going to take this as a question of private law as to whether the variation simply varied the contract or whether you've got a new contract. We're going to look at this differently. And what we're going to ask ourselves is, what does that phrase under the contract mean? And we think it means that the actual money you spent, the obligation to spend that particular money, was in the first 10-year period. How do we get that? They said, well, one of the things we're going to look at, where does this 10 years come from? Answer, it was part of a package of measures to encourage investment in deprived areas, which included a relaxation of planning laws, which also lasted 10 years. Doesn't that just tell us that that phrase, expenditure under a contract, means that looks at a world in which the obligation to spend that money arose in that first 10-year period? So what the Supreme Court did in Cobalt, you saw it yesterday, was to say, well, it's part of a package of measures that Parliament herself was enacting. That 10-year limit is explained in a particular way. We get that. That tells us how Section 298 of the Capital Allowances Act should be construed. I think that's neutral, that approach, in the case before this court, this case. We know from the explanatory notes, we know from Spotlight that the Revenue were worried about Rangers. We do. And what Parliament enacted, knowing the width and scope of the in connection phrase, they knew about Barclays. Parliament's reaction was Part 7A. And that is properly, in my respectful submission, construed on its terms. This court doesn't need any addressing really by me about how it would be unhealthy as a matter of statutory construction to look at communications by the executive to do anything more than explain what Parliament might have meant. Part 7A was a reaction to a worry about Rangers. We all know that. This is what we've got. Does it encompass Dr. Thomas resolving to fund a trust in order to make a loan to him? We say yes. So, and I don't need to show you Parker. You have it. This court is well aware of Parker. It wasn't just anybody, it was Lord Wilberforce, who says you may well have a world in which a particular provision was designed to counter a particular mischief, but construe the words properly. And that's where we are. Put another way, you take this as a visceral point. Dr. Thomas has got this loan, which on the facts he thinks he won't have to pay back. The right answer, but it's taxed under Part 7A. If the way he got that loan was to use his directorship and he's the only director. Might be a return on his investment, I'm stuck with that finding, so on.
What Mr. Firth fundamentally submits is that if the FTT's construction is wrong, and therefore the construction he advances before this court, which he says is a purposive construction, if that's wrong and HMRC's construction is correct, he says it is not obvious what the purpose is. Why would Parliament wish to tax this as income tax?
Do you want me to answer?
Yes. Why, on your submission, why is Parliament trying to get at this money?
Because Dr. Thomas, co-director, got the company, of which he was the only director, to fund a trust to get that money paid to him as a tax-free loan. And Parliament says, well, in that world, it's not tax-free. You have used your position as director, literally, for resolving that MDPL funds a trust to make you a loan of that very money. What's wrong with that? You should bear tax.
So I think what's implicit in that submission is that it's not only where there is remuneration, or part of the reason for remuneration is employment. In other words, the causation point. That's not the only scenario in which Parliament may wish to tax income.
It's the opposite. That's why I started with this. The regime which taxes remuneration, rewards, wages, that's Section 62, that's general earnings. Or, as I say, it's close cousin by reason of employment for benefits, for million, as an example. And then there's a different family of self-standing provisions that Parliament wants to tax, where it's not wages, or needn't be. It's a different test, the in connection with test. So really what I'm saying is exactly right, my lord. Exactly right. Parliament isn't confining herself to taxing wages, rewards, remuneration. It's the opposite. Can I please, because I feel like I'm on a roll on this response, show you Barclays? Because I'm going to show you 3 cases: Barclays, Mather, and strategic branding. Each one of them makes good the point that I've just made in response to your lordship's observation. Parliament isn't just taxing wages, remuneration. It's a different family of sections using the in connection with. Now, what happened in Barclays, it's tab 19, page 266, and I think it's volume 1.
It is.
Keep saying it's not remuneration. I mean, it can't be pure coincidence that this trust he set up is called a remuneration trust.
Really, my lord, I can't agree more. And it was sold as a scheme to generate a tax deduction for the company as well as a tax-free reward for him. Really. Anyway, I won't work myself up into anti-remuneration rage. I think please may I look at Barclays. Now in Barclays, this is what happened in Barclays. I know well. Barclays Bank provides a scheme doing tax returns free. But the class of beneficiaries wasn't just employees, it's and former employees, pensioners. It was also their spouses. And the question for the court, and you'll find this on page 269, paragraph 3.
Yes.
In a world in which Barclays said, we're going to stop doing this, but because we want to keep the trade unions happy, amongst other reasons, we're going to pay some money to you. And what you will see is that the relevant taxpayer is the recipient of that money. So not just the pensioners, but also their, if they die, their widows or widowers. They never worked for Barclays. Held, they're taxable. The relevant section defines relevant benefits. Please may the court look at it, paragraph 3. Any pension, lump sum, or like benefit, so on and so forth, in connection with past service. And what I had held wrongly was that that meant somehow that this money given by Barclays to the beneficiaries had to be some form of reward. And I was wrong. In paragraph 10, page 270, I'd found as a fact that these payments were made to avoid perceived pensioner and trade union hostility. And if you turn the page, please, to the top of page 271, I'd also found the payments were not in any form of reward for those past services, were paid not only to former employees, but to their widows and widowers. They were calculated by reference to the complexity of their tax affairs, the age of the recipient, and the extent to which they used the services without any reference to part service. So I said all that. And if you go to, please, page 272, paragraph 16, it's picked up by Mr. Peacock at the top. Please do you see? The very top of the page, factual context of the present case. Mr. Peacock submits the proper inference, so on and so forth. He's saying the same. He's saying what I said. Held, forget it. It's in connection with. Why? First, at paragraph 18, you've seen this. In connection with means having to do with. So far, that hasn't disturbed the point made by my lord, that's an ordinary phrase in the English language. And then, taking it short.
Well, that's what the majority, sorry, in Coventry, there's a quotation from Coventry, Lord Hope's speech. The majority in the Court of Appeal had said that it was a sufficient answer to construe the words in connection with as meaning having to do with.
Yeah.
But it doesn't seem to stop there.
It doesn't, but if it had, it would be fine by me. But my Lady Justice Arden, as she was, went on to explain that a connection may be direct or indirect. That's in paragraph 20.
Yes.
And that's, as it were, holding that thought that connection means having to do with. And then at 22, she's asking.
I'm so sorry. I'm sort of having a trip down memory lane as I look at this. Isn't one way of formulating all of this is the phrase in connection with? I'm just reading from that extract from Coventry Waste. The phrase is a Protean one, which tends to draw its meaning from the words which surround it. And Protean, I think, just means it's chameleon. It takes it's a phrase that we've seen it said here in different ways. It's a phrase which can mean different things in different contexts. So you have to look at the surrounds. I mean, that's all that anybody is doing in these cases, is just saying, well, these are the words I've got. They can mean different things in different contexts. So what do they mean here? And there's a consistent line that then runs through, and I think all that Lady Justice Arden is trying to do is exactly that in the context of this case, isn't she?
Exactly right, my lady. And that's why I keep saying, I don't know why it's got under my skin, but the charities payment isn't a thing. Because number one, you're not in the section at all, which is not made by a third party. It's only when you've done something odd that this money is going through a third party, not the employer. And what's more, as my Lady Justice Whipple has just said, and I respectfully can't improve on it, is you take these ordinary words, they mean to do with, and you say, well, I've got one of those here. Anchoring that question in, do you have a relevant arrangement? Is the essence of it something to do with Dr. Thomas's directorship? That's your tick. In the same way as in London Luton, if conversion means physical conversion, do all these fees have something to do with that physical conversion? No, they don't. And bless you. And there are two equally bad mistakes one can make. One is just to be glib to say, well, it's all very easy. It just means to do with. No, you look at the facts, you look at them realistically, and you ask, do we have the relevant relationship, the to-do-withness here? The other mistake would be to try and make some sort of formulation that applies in the same way in every case, like an algorithm, and that's what Lady Justice Arden is saying you can't do here. You shouldn't.
But do we have to do anything more than say, as you say, look at the facts in a realistic way and ask, is A in connection with B? Why do we have to keep trying to find some other words? Why can't we just apply the words used by Parliament?
But I'm not asking you to do anything else. I'm saying...
No, but the authorities do seem to say that we have to do that.
No, well, maybe my Lord and I are in slightly different places on this, but the authorities don't say, as I read it, what they say is this phrase is capable of meaning different things, and whether alone is in connection with employment needs to be looked at in the context of the whole purpose of interpretation of legislation.
Yeah. I don't disagree with my lady. It may be that it's the word meaning which is causing difficulties, at least to me. I can understand that the application of the words used by Parliament may differ according to what you're dealing with, but why do we have to find some meaning for this phrase rather than just applying the phrase that Parliament is?
This is where I can answer this. This is what I'm talking about when there's a danger of overthinking this.
Yes.
You can either take what I'm going to call the algorithm approach. You think I can find some perfect meaning of the word in connection that will give me the answer to every case, no matter where it's located. That's a mistake. It's a bad mistake. It's juristically sloppy. Why? Because that phrase will appear in different sections which cover different fact patterns with different legislative ambitions. So one says...
They can ball through the tax bar as well, I assume, if you found an algorithm that defined it in every case.
Yeah, I suppose so. Yes, I don't know what to do with that.
No, I mean, the point is, it's an ordinary phrase that is readily understandable, but precisely how it applies in any given case will depend on the facts.
And that's where I think the point made by my Lord Justice Singh has unearthed, as it were, an unnecessary problem in applying this phrase on a case-by-case basis. You can either have a frankly sterile discussion of what the phrase in connection with means, a kind of Platonic definition. Or you can say, look, it means having to do with, and that's going to vary from section to section, provision to provision, fact pattern to fact pattern. I'm going to do that.
But it's not just the facts that drive the meaning. That's really important, isn't it? That you can't just say in connection with means to do with, and let's just see if fact A is to do with fact B, because that would corrupt entirely the purpose of the statute. And London Luton might be the best example of why meaning takes meaning is context dependent, because as I remember it, and I think you're better at this case than I am, the payments in question were fees to consultants. And the question was whether they were in connection with the conversion of the property, as far as I remember. And there was no doubt that on a factual basis they were connected, because that's why the fees were paid. The whole issue was that what the statute meant?
I can't agree more, and that's why it was so important that this court found, as your ladyship did, that conversion meant physical
Yes.
conversion.
And so in that context, it was in connection with meant something quite narrow. And the first tier tribunal and the upper tribunal had given a permissive, wide meaning, just saying words mean words, and that's what the language, that's what the statute tells us to do. And it was this court, I don't know if it's under appeal, but it was this court that said, well, no, that's not right in context. It's just,
It's not going any further. But the absolutely right. But that's what I said, that you can't take the phrase in connection with out of its
yeah,
context. That's what de-anchors it,
classic piece of statutory interpretation, isn't it?
but of the whole statute.
Yeah, yeah.
And that's why I'm saying in this case, here it comes again, relevant arrangement is the essence of it. Does it betray, reveal a connection of the loan on the one hand and Dr. Thomas's directorship on the other? Well, of course it does. He has used that directorship to get himself this loan in a world in which it was made by a non-employer. That's why the legislative context my lady speaks about is so critical. Because all these other examples of dividends paid by a company to the shareholder, who cares? Yeah, and what's more, there's no relevant third person. You've done something weird, huh? You have made a payment come to you through somebody who's not even your employer. Then you interrogate, otherwise nobody cares, this section doesn't apply. What I think the courts below this court did in London Luton was precisely what you shouldn't do, which is take this phrase out of context and try and come up with this algorithm.
They took the glib view.
Yeah.
I don't know about the algorithm, but they just said in connection with means in connection with, their words of wide meaning, and construed them as they thought correct.
Exactly right. So that's why I'm saying that there really isn't, we can work ourselves up into a violent agreement that there really isn't a problem here. And what I'm inviting in my submission is for this court to say, is there some, does the loan have something to do with Dr. Thomas's directorship? You've got my submission.
Yes.
Or did you get it? Just while I'm at it, I'll take it very short, but please may I show you Mather and strategic branding, only because it will make this point, I think, good. Mather is volume 3, tab 36.
Page.
Page 840.
840.
840, my lord, yes. I'll take it very short. I'm very sorry. I'll wait.
In my bundle, 840 is volume 2.
Yeah, it's volume 2, I'm afraid.
I'm very sorry.
No, it's all right.
There's a really good index that Mr. Firth's handed up, and it's got the volumes in it now. It's just that inevitably my volume is different to everybody else's.
Don't worry. So 840.
Please. Now, what Mather was to do with was a settlement payment, because the taxpayer, this lady had been fired, and she'd gone to the employment tribunal, and there was a settlement agreement. So it ended up not being the hearing was not litigated before the employment tribunal. and she'd been fired for, on grounds which she had said included discrimination, all sorts of bad things. And the question was this a payment for tax purposes, in connection with the termination of employment? And what was said by the taxpayer is, oh, no, 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 no. I know we said all that in the employment tribunal, that she was fired by by Deutsche Bank for bad reasons. But actually, if you look at the facts properly, what you'll find is that it was a horse trade. That's what a settlement is.
So it was a what?
Horse trade.
Yeah. Yeah.
She was being a nuisance, and they paid her this money to go away. If she had litigated, she wouldn't have got anything, or not very much. There's no connection with termination of employment. What the Upper Tribunal, I think my Lord Mr. Justice Miles was one of the, who's really quite a direct judge, who said, well, really, no. The trigger was the termination of employment, her getting fired. What would you want? And what's more, of course it's supposed to be construed widely. And there's no severance of any connection. So I'll show you. There's not too much to see. Paragraph 32 on page 851. This is the section that the Upper Tribunal were looking at, section 401 of ITEPA. And the phrase was, if you look at little 1, received directly or indirectly in consideration of blah, 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 or otherwise in connection with termination. So that's this phrase again. And I, please may the court look at paragraph 65 and page 857. And I respectfully adopt that. The final catch-all test within section 401 is provided by otherwise in connection with the link between the payment and the termination can be broader than a standard causative link. Does not require a sophisticated or legalistic analysis. Exactly, my Lord Justice Singh's point. And to pick up the end of that paragraph, it's over the page, 858. Last sentence of paragraph 66, it begins, once it is established on the facts, if the court has that.
Yes.
As the FTT found that the settlement payment was directly or indirectly in consideration or in consequence or otherwise in connection with the termination of Mr. Muthi's employment. It was a miss. Anyway, then it's within section 401. Oh. That was looking at a different case called Who, but I adopt that. And then at 72, as it happens, it's a frankly sterile linguistic point, but what the Upper Tribunal says is, in looking at these sections, don't parse it, don't overthink it, just read the section. And then strategic, that's all I want to take from it. And none of this, my Lord, just addressing my Lord Justice Singh, is disturbing the notion that in connection with means anything other than what it does naturally speaking. None of it is. To do with, but in the context of a statute. Please now look at strategic branding, that I think is divider 2, tab 29. 617.
617.
Yes, thank you.
Yes.
Now, Now, strategic branding was literally the scheme. It's the same steps and literally the same questionnaire. You know the questionnaire that I took Dr. Thomas to, where he answered questions and they weren't true. It's the same questionnaire that appears in this case. This case is heavily marketed. This scheme was heavily marketed. You can see that if you look, please, starting at page 618, you've got this steps, and then moving on to 620. I'm going to take this very short, but I do want to show it to you because I think it will underscore the point I want to make. You can see it's from paragraph 11 all the way through to paragraph 22 on page 621. It's exactly the same scheme. And then at paragraph 23, you will see the same resolution as you've got in this case, with the same answers. Now, I want to show you two things with your permission, because it will save me going back to it when I deal with the CT deductions. The first year tribunal disagreed with Judge Morgan's analysis, both of Part 7A and the CT deduction, and it's just convenient, with your permission, to show you now. Please now go to page 663. This is dealing with the CT deduction. You remember yesterday when you were addressed by Mr. Blade saying, oh, there was a finding of fact at paragraph 159 of the FTT decision in this case that the tax avoidance was only incidental. The tax deduction was only incidental. And I object to that categorization because no, what the FTT did in this case, I'm trailing it now so it's in our heads, was the following. One, they treated the test for Part 7A as being exactly the same, not as the Upper Tribunal said, roughly the same, exactly the same as the general earnings test. Paragraph 137, I'll show you that. Two, it was on the counterfactual assumption, this is the FTT in this case, that the payments were earnings, that the FTT in this case decided that they'd be wholly exclusively. Not finding a fact at all. So bearing that in mind, and the reason that's important was this was all put to Judge Zaman in strategic branding, saying, well, Marlborough decided the case in favour of the taxpayer, so should you. And she's saying, well, no. Why? Paragraph 161 on page 663. What she says, turning over the page, is put short. Judge Morgan, in Marlborough, this case, right at the end, you see it, expressly proceeds on the assumption that the relevant sums are earnings.
I'm sorry, where are you now?
Page 664.
Yes.
At the end of paragraph little 1. Do you see there's a however?
Yes, thank you.
So what Judge Zaman is saying is, no, I'm not going to follow Judge Morgan on wholly exclusively because she expressly made her findings on deductibility, the CT deduction, on the basis that there were earnings, and that's the wrong approach. And she then gives her own analysis why they weren't wholly exclusively in this case. Going on to part 7A, please may I go to page 679, paragraph 207.
Yes. Thank you.
So that's where her analysis begins, part 7A. And then at 220, Judge Zaman in strategic branding says, if you see 220 on page 683,
Yes.
I respectfully disagree. And what you're saying put short is not the same analysis as it is for earnings. And then at 222, interesting, because I said construe it broadly, and she said I'm not going to do that. But if you look at my submissions, she did accept those at 223 and 224 and 225.
She does say at the end of page 683, I see no reason to construe them, other than by reference to the language actually used.
Absolutely right.
So she was rejecting there. Excuse me, this may be where the interest in the case is. You were saying it's a broad, means something broad, and she said, well, I don't like that, it's not broad. I'm just going to look at them, look at it with the surrounding provisions of Part 7A, the natural meaning within that context.
Exactly right. And I can't argue with that. That is the correct approach.
Is this going any further?
No.
So that is the correct approach on your submission. We don't argue with that.
So what I want to do is, and I'm doing all right for time.
Good.
What I want to do is bring together what I've been saying, and then pick up the points made against me, look at the FTT and UT decisions, and then I'm done.
Well, you've got grounds 2, 3, 4, and 5 to deal with as well.
They all wrap into one. I'll explain when I've completed my submissions why I think I've met grounds 2, 3, 4, and 5.
Okay.
So we'll do that. If that's all right. So where I've got to is what's become a title submission that don't tell me there's no connection between Dr. Thomas's directorship and this tax-free loan he's got. It's not tax-free. If the loan is a distribution, I don't care. If the contribution is a distribution, I've said it more than once, and I'll show you why I say this. If the contribution looked at in isolation was not connected to Dr. Thomas's shareholding, but even if it is, and even if that is a distribution which is taxable in his hands, I still don't care. A, there's no double tax retrospectively as it happens, and B, even if that distribution is taxable, that does not undermine my analysis on the loan. Where I've also got to, just to trail, I'm going to call it the charity payment example, because it's a convenient shorthand for all the kind of inter orem submissions made that if in connection means to do with in a case like this, where would we all be? Answer, you're only looking at this stuff if the payment's made by a non-employer. That's one. Two, you're also looking at the in connection with an essence. I accept that. So even if you've got a relevant arrangement made by a relevant person who's not the employer, and there's a relevant step, of course the revenue will look at whether that payment to a charity buys a tax charge for Dr. Thomas. But really. But you're not going to get that far. That's why when it said, oh, taxpayers, they get to choose in these small companies whether they take a dividend or whether they take salary, well, keep going, go right ahead, because there's no third party making those payments. None of this stuff applies. And Parliament knew when she enacted Part 7A and the in connection with test, the width and scope of that test, because they knew about Barclays, where the widows got taxed. And if you want or have to go there, did Dr. Thomas choose himself as the recipient of this loan? Well, tick, that was the whole point of this scheme. Now, as I say, if I may please pick up the points made against me, and then I'll make sure I've dealt with all of grounds 1 to 5. Point 1, a loan. If you were using good 1960s language, you'd call it justum generis. But loan takes its colour from reward or recognition. No. 554F shows you the scope of what the draftsperson thinks is caught the type of loans. Now, it was said, oh, but if you look at a reward or recognition, that's an absolute payment. A loan is somehow a lesser benefit. So the in-connection test doesn't that just show the in-connection test should be construed in some narrow way? No, not at all. A loan, the whole point about a loan is that it's easy to make a loan because you don't diminish your net worth. It's an easy way to take money out of a trust or a company. If the court wants an example of the sort of payment that's caught by reward or recognition, Wilcock and Eve was mentioned yesterday. You remember the ex gratia payment to avoid a harm to your reputation? It's divider 17, held by Mr. Justice Carnworth. It was that case. Oh no! And he was grappling with which side of the line does it fall on, and is the from test and the by reason of test, do they ever amount to anything different? If you remember all that, held ultimately by my Lord Mr. Justice Carnworth as he was. No, it's not taxable. It's not from, constitutively speaking, or by reason of, constitutively speaking. That would be caught on my respectful submission on the in-connection test.
Right, that's interesting.
A loan, I keep saying it, but look at a case like Barclays. The scope and width of the in-connection test, and here you've got something much stronger, because I am choosing myself to fund, to be the recipient of the loan that I am funding with the contribution. This is again going to, I think, this is all the same point put in different ways. Where would we be if Dr. Thomas was not a director? Well, of course, we have to find a relevant employment or directorship, which would include a shadow directorship. If he's trying to extract money and he hasn't got a directorship that he can exploit or an employment, well, then that's a different scheme. That's a Clipperton scheme. And just again, I'm going to make this point. The whole point about Clipperton the reason that that was clearly a distribution made in respect of shareholders was because the scheme was sold as a dividends, a tax-free dividend scheme, and part of the arrangement, which I'm about to show you, involved the two shareholders. Yeah, there were also directors, it's true. Going into a shareholders agreement. That was part of the arrangement. There was no loan. So Part 7A, if it had to bite, would have to bite on the rewards or recognition. And nobody's saying it was that. And I'll show you very short because it makes my point good. I've lost my liberty. It's in the supplementary authorities, please. And it's tab 2 of the supplementary authorities. Now, if you remember what happened in Clipperton, I want dividends. There were two shareholders. Instead of taking a dividend of 100 each from the company called Yorkshire, they said, I know what we'll do. We'll put, just keeping the numbers simple, 200. We'll capitalise a subsidiary for 200. We will do that qua shareholders. I'll show you that. I will show you that. We will engineer a world in which that 200 is distributable in the hands of the subsidiary. The subsidiary pays a dividend to trustees in which these two people have got an interest in possession. So that dividend whistles up to them. And what was said is, but they don't have shares in the dividend-paying company, so that can't be a distribution in their hands. And what's more, the settlements code means that they can't be taxed on it anyway. Held by Judge Morgan. And it's right, this thinking absolutely informed how she dealt with this case. Said, come off it, that's a distribution from the top company in respect of your shares in that top company. And what my Lord Justice Newsy said was, you got it indirectly, so what? And if you please, I'll take it short, paragraphs 9 and 10. This was the plan, and we've got this engagement letter. But then paragraph 11, please do you see that? It's on page 50 of the supplementary authorities. Please do you see that? The appellants as shareholders in Win Yorkshire, that was the top co, gave consent to the extent under a shareholders agreement. So that was part of the arrangement, all right. That's what I'm saying. It wasn't open to the revenue to run an alternative attack based on Part 7A. In different facts they might, but not in Clipperton.
Yeah, just to be clear why that is so, it's because there's no reward or recognition.
That's right.
And it's not a case about a loan.
Exactly right. Because these dividends, to be in Part 7A, would have had to have been a payment by a non-employer, a non-relevant employer, so that's Win Scarborough, so we got one of those. But it would have to have been on the evidence categorised as a reward or recognition in connection with directorship. And that wasn't the evidence in this case, because the scheme was sold to them and implemented qua shareholders, and they signed a shareholders agreement which underscores that. If it was a loan, if it had been a loan, then to run Part 7A, the revenue would have had to establish a connection, and then they might have.
And you say that's the present case.
That's
And you say that is the facts of the present case.
but yes.
So it's distinguishable.
As far as I have to distinguish it, I mean, this case also, as it happens, And we mustn't, please, in my respect for submission, forget this. That contribution did two things. It wasn't just funding his tax-free loan. It was also trying to get a CT deduction, which is inconsistent with it being a distribution. The two things can't go. You do not get a CT deduction for a distribution. So, in this case, at its lowest, the optics are that Dr. Thomas was not acting as a shareholder. I'm not saying that there can't be facts similar to this case where he is. I'm not saying that. Nobody's saying that. In this case, the revenue can run Part 7A perfectly easily. Because the relevant payment was looking for a CT deduction as well as a tax-free loan to him. We do not say that that ambition means something can never be a distribution. We don't say that at all. But it's relevant. And he was the only director. Acting co-director, funding a loan to himself. It's different to Clipperton. It's a different scheme. So all we're saying is, if you're looking for marketed tax avoidance schemes for marketed individuals who are both shareholders and directors, you've got different schemes sold to different people. So picking up these points, please. I don't accept as a matter of the text of Part 7A, looking at section 554A, 554F, that a loan needs the stamp of some sort of reward or recognition. The correct test is not causative. In connection with means something different. And the point I've just been dealing with, the resolution in a different case could have been made by a different director. Well, then we have to interrogate whether there's a connection between some employment or directorship on the part of Dr. Thomas, and that is a question of fact. And here I'm not being glib. Same point, if it's made in Marlborough's skeleton, what if Dr. Thomas retired as a director? Well, then we have to interrogate whether the scheme was implemented in connection with his former directorship, or if he's a shadow director, or what. It's an exercise that would have to be carried out by a relevant court. It said, it's a return on investment. I've done that point to death, I don't care. If the relevant it is the loan. If it's the contribution, you have my submissions, there's no double tax, retrospectively. And I don't think the revenue need to apologise, even if they hadn't dealt with this retrospectively. Just about that, it's also said, the court, the FTT, made a finding of fact that this was a distribution. Well, they certainly did say, and I can't quarrel with it, and I'm not, that the loan was a return on his investment. They must have meant the loan. So I do think if you're looking for a distribution, the FTT must have thought it was the loan, not the contribution. It's a loan that got the money into Dr. Thomas's hands. I've said it more than once, that's an odd type of distribution. It can happen. And just about that, whether a payment's made in respect of shares or not, of course it's dependent on a finding of fact. But the question as to whether something's in respect of shares is a question of law for the court. I'm going to show you this. In Investec, which I'm about to show you, I hope it's volume 2, tab 26, page 511. what that case was to do with, it was all to do with partners in a partnership, and whether a capital contribution, money paid by the partners into the partnership, was deductible wholly exclusively, yes or no. And the FGT had held yes, it was. And they were reversed by the Upper Tribunal. And as you'd expect, there was a complaint by the taxpayer saying, "Oh, this was a finding of fact. How can this happen?" And the answer is at page 525. Page 525, my lord, paragraph 42.
I had the wrong reference. So paragraph.
42, please,
Thank you
my
very
lord.
much. Yeah, have it.
So it's got some echoes of what's said against me here. They're saying, "Oh, the Upper Tribunal," this is the appellant, it's the taxpayer saying, "Look," to this court, the Upper Tribunal erred. There was no Edwards and Bairstow's challenge. The FGT held it was wholly exclusively. Come on, this is all very bad.
Yes.
Then in paragraph 43, my Lady Rose, Lady Justice Rose as she was, says, "Well, no, you haven't understood. The revenue's not quarrelling with any of the findings of fact. Not doing that. What they are saying, the revenue, and this is paragraph 45, on those very findings, it wasn't wholly exclusively. And my Lady Rose sets out the facts. And then at 46, this is the point. First sentence. The question for the Upper Tribunal and now for this court is whether, given those facts, those capital contributions were as a matter of law wholly and exclusively incurred for the purposes of the sole financial trade. So the point she's making, and this is actually reflects what my Lord Justice Millett said in Vodafone, findings of fact, yep, that's for the fact finding, that's for the taxpayer fact finding, all that, fact finding tribunal. The question of wholly exclusively, because that's what Vodafone was about as well, that's a matter for the commissioners, it's a question of law.
Yeah, is that why you sometimes get in the law reports, you see the House of Lords reaching a view about that?
Yeah. Otherwise, none of these cases would ever get to an appellate court. The categorization is a question of law. So that's why I say, when I show you the FTT, I don't need to, I'm not challenging findings of fact in Edwards and Bairstow. I'm simply saying, as it happens, I don't think that the contribution or the contribution and the loan are distributions, although I don't really care even if they are. But I do get to say neither the contribution nor the contribution plus loans were distributions. What I called interorem submissions, payments to charity or choices of participators who are also directors in companies, taking dividends or salary, none of that's relevant because this section only bites if the relevant steps are taken by a relevant third party who's not the employer.
I think another, and don't deal this out of turn, please, but another fundamental plank of Mr. Firth's argument, as I understand it, is that if the FTT's construction is wrong and your construction is right, then that offends against legal certainty. Because no, he says nobody knows, including you, in what circumstances you can tax. The tribunal doesn't know in what circumstances it should allow an appeal, and so on.
My respectful response is any tribunal will have to, in the context of this provision, ask, do I have an arrangement? Do I have a relevant step? Is one to do with the other? In a world in which the relevant step has been taken by somebody who's not even the employer? And if I say yes, taking into account relevant evidence, I reach an answer. And I did promise yesterday that my approach, I deal with predictability, consistency, certainty, welcome to parts of the tax code that depend on findings of fact. In Barclays, I don't think the widow is expected to be taxed. But it's the right answer that they did. So it's not. It's another inter rorem submission. This section depends on findings of fact. In a world in which Parliament has actually given us quite a solid anchor. That's not the right metaphor, but anyway, an anchor which works, because none of this stuff applies unless the relevant step is taken by a relevant third person who's not the employer. And given that the relevant step being taken by somebody who's not the employer, it's incumbent on the revenue to establish what evidence shows there's nevertheless a connection between the relevant step on the one hand and employment on the other. And I say in this case, we've done that. So it's not right, it's not true, or any words of that nature to say this leaves us all in the dark as to how this stuff plays out. There are cases, I don't particularly want to go on and on about this point, but there are cases in the tax code which this court is well aware of, where the appellate court says, well, we might have come to a different answer, but it depends on findings of fact, and it's not Edwards and Bairstow. As I said, welcome to a world in which the tax code operates by reference to findings of fact. And the burden is on me to show this court why I'm right to say that on the facts of this case, the relationship between Dr. Thomas's directorship and this loan is visible, strong, and undeniable. I can't say more than that in response to this point about, well, there's no anchor. There is an anchor. It also deals with, as it happens, that this notion was set against me in the FDT and the UT, I think, that, well, companies have to act through their directors. We're back to my Lord's Charities point. Well, I know that. I don't need to be told that. What I'm interested in is a world in which that directorship is part of a relevant arrangement where something is done by somebody who's not even the employer. Please may I show you, oh, sorry, just while I'm at it, I almost forgot the CT deduction. My submission is that there is no pleaded business purpose at all. The purposes of the resolution were untrue. And you'll see that not that far below the surface, the revenue was criticised. I was criticised by calling that out, by saying these are untruths. The revenue doesn't apologise for that. They were untruths.
You've got that finding, haven't
Yeah. Yes, Mandy. There is no pleaded business purpose. What I'm saying is there was a dual purpose, as it happens, from the very beginning of getting a CT deduction and funding a tax-free loan to Dr. Thomas. That's duality right there. As we also know, all of the other expenses of the business, they'd already been paid, the hygienist, the associate, all that. It was to empty, Dr. Thomas's words, MDPL of profits. So there's no business purpose.
So is this ground 5?
Yes.
Yeah.
I will map what I've been saying to the grounds 1 to 5 when I finish, my lord. But,
Right.
but it is ground 5.
Right.
And that's all I want to say about the wholly exclusively. I don't need to say anything more. The court has my submission that on the facts of this case there is no pleaded business purpose. The court is
So
very
it may be convenient if we are in this context, if we can just remind ourselves of what the Upper Tribunal said about this topic at page 111.
Can I take you to that when I get there, or do you want me to do that now?
Well, no, it's entirely up to you how you order
Yes.
your submissions.
I'd like.
There may be additional points that can be made.
There's quite a few. Can I just pick those points up when I
Yes.
show you the Upper Tribunal and the FTT, because I need to show you those to reassure this court that I'm accepting all the findings of fact made by the FTT.
Yes.
They don't disturb the submissions I've just made, and I'm that the FTT went wrong in law on Part 7A for the reasons I've explained. That they said it was exactly the same as general earnings. And also that they went wrong in law on wholly exclusively, and they didn't make a finding of fact. And then I'll show you the UT to say, well, when they remade the decision, the UT, if they didn't get it wrong, they made a meal of it on Part 7A and on the
That's
right.
fine.
on
That's fine.
CT.
Mr. Ghosh, you take it in the order that you think
Thank
right. I will just gently remind you, if I may, that it's 12:30, and so although there's no strict time limit, I think we were all expecting that you would, and I think you were expecting that you would finish by 1 o'clock.
I did say, but I also said I didn't promise, but I'm going to try.
No, I
And
understand that.
any of you will leave Mr. Firth an hour for his reply.
Yes, fine. Thank you.
So, please may I look at the FTT decision? It's
Yes.
core bundle divider 15, page 152. And I will take this short. It is obviously critical that I can show you that I'm right when I say it made an error of law. So page 153. Paragraph 2 summarizes the scheme. Please, may this court look at paragraph 3. There was no dispute that the sole purpose of the scheme was to extract MDPL's profits into the hands of Dr. Thomas, and put short, to get a tax-free loan and to get MDPL a tax deduction. Going to page 155, paragraph 10, which sets out the background. Picking that up, so we know he's the sole director, we know he's the sole shareholder, that's para 10. Para 11, he used to operate as a sole trader, so not incorporated. But he first used this scheme, these arrangements, when, look at paragraph 12, please, when he was still operating as a sole trader. Paragraph 13, he says, well, he thought the scheme was where MDPL gets its tax deduction and he gets loans. Paragraph 14 I can take short because the court is well aware of how the scheme was implemented, so I'll move on. But can I please ask the court to look at this resolution, this resolution that I've been going on and on and on about, at paragraph 17, page 158. And there you've got I said it was the same questionnaire as you'll see in strategic branding. Same questions, same answers. These were the purported reasons why MDPL was making these payments into the trust. They're not true. Paragraph 20 and 21, put short. None of these beneficiaries knew that they were beneficiaries of this trust. Paragraph 32, page 162. That just tells you, we looked at the accounts below. I'd wanted to show you these, but I've withdrawn my application. In paragraph 36, Dr. Thomas MDPL acted on CW, that's Baxendale Walker's advice. He spoke to some other people. Paragraph 38 tells you that it's this 10% fee that he paid on each time he made a contribution. And then the purpose is at paragraph 41. And there you've got the finding of fact. That when he was giving evidence, he meant that if he hadn't done this scheme, paragraph 41, little 2, if he hadn't done this scheme, he would have taken money by way of dividend. And for this court, I accept that. He does say at little 3, precisely the same amount would have been contributed to the trust, whether he held 100% or 75%. Now, paragraph 43, that's where he accepted that he would have received 100% of the contributions as loans, even if there had been another shareholder. That's what I said you should be finding. And they say, no, we don't accept that. We know he said that the contribution would be the same if he'd held a different shareholding. But he wasn't asked if he would have still received the loan. Now that's not correct, as the court knows, but in any event, all I'm saying is here, the FTT, given that it found that a payment was made in respect of shares, seems to be looking at the loan. It seems to be identifying the relevant distribution as the loan. Because they've said, we've got a question all to do with the contribution, and that would have been the same even if he had different shareholdings. But you didn't ask me about the loan, Mr. Ghosh. And then at 44, you'll see that 1, 2, and 3, when I was asking questions, his response was he was told all sorts of things. And then at 45, you see that the FTT says, we take from the above evidence that Dr. Thomas had been told it was part of the plan for getting the desired advantages. Trustees had to have the ability to refuse to make loan to him, but he had no reason to think that in practice. So he put short he wouldn't get it. And then 46, you wouldn't have to pay this money back. That's what makes the observation of the FTT at 49 a bit odd. Because it was put to him that the loans he received had nothing to do with him holding shares. He said that's what I was told, but they say, he was just told that. We don't take that as evidence that there was a disconnect between the loans and the shareholdings. And I can't face saying too much about this. That finding is what it is. And then at 52 and 53, Tribunal's clear that but for this scheme, this arrangement, he would have taken the amounts as dividends. And just, well, to be clear, I mean, it's obvious, but it's clear. So what? He did this scheme. And if Part 7A applies, he takes priority over distribution treatment. And I wonder if I might just take the rest of this short, because as I say, the findings of fact that Mr. Firth said, gave you and delivered to you yesterday, a return on his investment. If he hadn't done this scheme, he would have taken dividends. That's what he takes now. Other people take dividends. We accept that. So then we get to the discussion, and that starts at 68. That's all to do with earnings. That's page 170. And just to be clear, it's no part of my case that to be a distribution, it has to be a formal dividend. I didn't say that, but in any event, if we pick it up at paragraph 129 at page 188.
Yes.
And you've seen this. These are the findings of fact. As I say, I can take short. I accept every one of these. I have to. Although, if you look at little 4 on page 189, I didn't say Dr. Thomas's evidence wasn't relevant. I said the opposite. But anyway, 130. Now here we get to the in a sense the problem which I think led the FTT astray. They're saying there's nothing to prevent the sole owner and director of a company from arranging the profits to be extracted in form of salary and dividends in such proportions as they want. I'm not saying any different. I'm saying if you're going to do this through a third party who's not even the employer, you're in a different world. Anyway, there's a lot of criticism of my submissions and me, which leads to the FTT to say, well, they're not earnings. But the Part 7A analysis is at page 132 of the taxable under Part 7A. And actually fast forward to paragraph 137. Because you've seen this paragraph. But here's the error of law. For there to be a connection, the employment must be part of the reason. But what does the learned FTT judge mean by reason? An assessment whether it's reasonable to suppose that in essence the RT arrangement, so far as it relates to Dr. Thomas, is a means of providing or otherwise concerned with the provision of rewards, recognition or loans, this requires essentially the same analysis as that set out in relation to whether the relevant sums constitute earnings. It could hardly be clearer. And we get that. We know that's what she meant, but it's not. It is in fact the same. When we look at the FTT's approach to deductibility, that's why I showed you strategic branding. If we start at 145, page 197, at 145, the FTT, what they're looking at is if this money, the relevant sums, and here it is the loan, or the contribution, if we'd won on Rangers, are taxable under ITEP. So she's considering both. She's thinking of a world in which it's taxable either as earnings or Part 7A. If you go to 159, this is why I say it couldn't be clearer. She's agreeing with Marlborough's view that Marlborough would be entitled to deduct the contributions in computing its profits for corporation tax. Little one, at this stage of the analysis, we're acting on the assumption that the relevant sums constitute what word? Earnings. That's what she thinks she's done at paragraph 137. She's making this assumption that she's wrong.
Would it be helpful if we can just go back for a moment, if you don't mind, to page 154? Where the FTT summarised its decision at paragraph 8.
154 of the core bundle.
Yes.
Yes.
Yeah.
At paragraph 8 at the bottom,
Mm.
it says in summary. So
Yeah.
very helpfully, the FTT gives its conclusions and then sets out its reasons later. And the first decision is that we have decided the relevant sums are not taxable under the general rules or under Part 7A.
Yeah.
On that basis, yeah, we can all read that. Then the second holding is I have decided that if the conclusion in one were to be incorrect, MDPL would be entitled to a deduction for the amount of the contributions for corporation tax purposes, and she exercises her casting vote.
Yeah.
And is it significant on your submission that the judge is clearly there treating the decision under Part 7A in exactly the same way as the decision on general earnings?
Well, it is, my lord, but I want to be fair to the FTT.
Yes.
You know, nobody wants to be, I've been there, nobody wants to be criticised for a slip. So that summary is consistent with what I say her analysis was.
Oh yes, I'm not suggesting anything different.
And that's all, but that's all I'm taking from paragraph 8.
Yes.
She's telling us I've got two things to look at: general earnings, what she calls the general rules, and I've got Part 7A. I don't think it's taxable under either, but if I was wrong, you'd get a CT deduction. She doesn't tell us what test she's applied for Part 7A until 137.
Yeah. No. We're not disagreeing.
Yeah, I'm just saying it's consistent with my
Yeah.
take, and indeed Judge Zaman's take in strategic branding.
Yeah. And it may be consistent with how the Upper Tribunal regarded what the FTT had done.
They do that in paragraph 170, which
Exactly.
I'm sure.
Exactly.
But, so,
yeah,
yes.
yeah. That's all I'm suggesting, is that it's helpful to see how the FTT structured its decision and how the Upper Tribunal perceived its structure to be, because that may help to explain their reasoning at paragraph 170.
Exactly right, my lord. And all I'm saying is this seems to be a universal view of what Judge Morgan did, because that's what Judge Zaman also thought in strategic branding. That's all I'm saying.
Right. Thank you. So I interrupted you. You were at page 201, I think.
Well, that's all I want to really show you from the FTT,
Right.
because I'm
Fine.
saying that all the facts fine by me. Investec tells me that if this court needs to grapple with, whether either the contribution or the loan was in respect of shares, that's a question of law, see Investec. I don't care. Because if it's the loan, 554Z2 deals with double tax and expressly contemplates it could be both. If it's the contribution, we've got this 554ZB, 55411ZB and 11ZC, retrospective protection of double tax for the contribution.
Yes.
But just to be clear, although Judge Morgan talks about this being a return on the investment, she must be talking about the loan, not the contribution, because that's how he got the money. I think with the court's permission, what I'd like to do is to take the court through the UT decision.
Yes.
Again, it's not going to take very long. And then after lunch, again, I'm not going to be very long, show you, please, the supplemental decision and the decision which refused us permission Rangers, because they're both illuminating as to what the UT thought was happening. But it's really not going to take very long. So the UT decision, tab 7, page 74. And just for good order, because they remade the decision both in Part 7A and the CT deduction, Para 14 tells you that the purpose of the scheme was CT deduction and tax-free loan. That's page 75. Paragraph 62 and 63 are important on page 87. Because what the Upper Tribunal says there is it was wholly unclear whether the revenues, what the FTT actually did on the CT deduction, but it's only a live issue if the contribution or contribution plus loan, whichever candidate, is not a distribution. You don't get a CT deduction for a distribution.
Where do they say that?
62 and 63. But it's also clear, I mean, companies don't get deductions for distributions, they just don't. So wholly exclusively arises if and only if Marlborough didn't make a distribution. That's not controversial. That can't be controversial. I'm just skipping through quite a lot because I really don't need to show you anything until sorry, no, it's a tense moment as I say until, but there it is, until 122, page
Yes.
101, paragraph 122,
Yes.
101. So this is their discussion of part 7A.
Yes.
And then picking it up at 146, at page 106. Well, actually, 145 tells you what is different from the causal connection, the causal test in general earnings. What they didn't say was that it's part of this family of self-standing tax charges, which includes Barclays, which uses in connection. 146, they say it's not a limitless meaning. 147, they say that Judge Morgan didn't say that general earnings and Part 7A was the same test. I think that's just wrong. She clearly did.
Sorry, which bit was clear?
147, my lady. And then at 148 they say, oh well, but she was wrong in saying it had to be part of the reason. And that's one of the problems with framing the test the way that Marlborough's framed it, to say, well, it's the same type of test. It's got to be part of the reason, but maybe not just quite as strong a reason as the from employment or by reason of employment type tests. We say it's just a different test in connection with. And then at 149 and 150, this is the Upper Tribunal explaining why the revenue wins on Part 7A. And they say I'm wrong at 149. They say, well, it's the point that he used his directorship to get himself a tax-free loan, so he hoped. And they're saying, well, that's wrong, because all companies act with directors. And I think you have my point on that. Yes, they do. But where the payment's made by a relevant third person who's not even the employer, you interrogate whether there's a connection.
So did you say they went wrong at 149?
Well, they say in saying it's
The
not
mere
enough.
fact that it was the director who asked for the loan to be paid to himself wasn't sufficient. You say that's wrong because that isn't
I
sufficient.
say put it like that, it's wrong because it was this director
Yeah.
with this director's knowledge implementing this scheme. What they've done is to say, oh, well, all directors go around doing all sorts of things for the company. The mere fact there's a resolution can't be enough. But my lady, yes, exactly right. It was this director who made this resolution. But 149 and 150, they do bleed into each other because that's why they were groping towards the sort of point I was making. Because they were saying, oh, but he was the only director. And all the profits that Marlborough made. And let me be clear, they should have said, and of course those profits include, as it were, the efforts of the hygienist and the associate. Of course they do.
Yes.
But they've been paid.
Sorry, they've been
Paid.
yes. Yeah, I did infer that. I mean, when you read the judgment as a whole, and also the first few lines of paragraph 150, they make that point. But can we just go back to 149,
Please.
if you don't mind? Because this was a submission of yours that they rejected.
Yeah.
But you invite us to say that actually it was correct. And so it may bear some close examination. The first 4 lines of 149 are these facts, which you say are undisputed facts on the FTT's own findings.
Yeah.
First of all, Dr. Thomas acted as the director of MDPL. In that capacity, he resolved to make contributions to the RT. Shortly thereafter, he would write to BTIL on MDPL headed page asking it to consider advancing a loan to him. This is your point about it's not, for example, payment to somebody else like a charity. It's a loan to him. A loan would subsequently be made by the RT to him. But they say, in our view, all of that of itself is an insufficient degree of connection to his directorship for the loans to be regarded as made in connection with that office. And the reason they give for rejecting your submission is a company can only act through the agency of its directors and employees unless it acts in general meeting. Well, you say, yes, that's uncontroversial, but so what? Because that's not a complete summary of the facts that you've just been summarising in the first 4 lines. We consider that resolving to make the contribution and requesting the loan were not sufficiently closely connected with Dr. Thomas' directorship. You say that's wrong.
Yeah, well, the facts. It's just wrong. And it's a categorization of law. Just to be clear, it's an investec point.
Right.
Because we're asking, is there a connection for the purposes of 554A?
Yeah.
I'm saying tick.
Yeah. So you say in connection with, once you've got the findings of fact, they can't be disturbed otherwise than on Edwards and Bairstow grounds, but you're not trying to disturb them. On those findings of fact, which you summarised, the first 4 lines of 149, the conclusion in law has to be, this comes within the statutory language.
Exactly right. And that is precisely what's said in investec. Nobody's arguing about these findings of fact. I'll be quick. And that's why at 150, when they talk about he was the only director, that's all relevant, but it should have been relevant 1 paragraph previous.
Right.
I'm in the court's hands. I can either finish this before we rise or come back. I'm not going to be very long. I plan to be no more than half an hour, 40 minutes maximum.
In that case, then I think we should break now. If you were going to be only a few more minutes, I'd be happy. But I don't like interfering with the staff's lunch hour. And so we will rise now, and we look forward to hearing you again at 2 o'clock.
Court rise of people.
Thanks.
town over lunch or something.
Again, I can't think of what the emergency would be. Thank you.